Hello, my name is Ros Prince and I'm a partner in Stevens & Harwood's Fraud and Asset Tracing team. In this webcast series, we're looking at the toolkit of injunctions available to claimants in fraud litigation. We hope these webcasts will be of interest to insolvency practitioners, in-house counsel and foreign lawyers. Today, Carla Shirin-Griffin, an associate in our Fraud and Asset Tracing team, will be discussing third-party disclosure orders, also known as Norwich Pharmacal orders.
Hello. Today I will talk about two of the remedies which are available to victims of a fraud to obtain information from third parties. I will discuss, firstly, Norwich Pharmacal orders, which are available to any litigant and even before proceedings are commenced. And secondly, orders under Section 236 of the Insolvency Act 1986, which are only available to the officeholder of an insolvent company. This webcast is relevant to insolvency practitioners, but also to other claimants and potential claimants. In determining which of these paths to take, the prospects of obtaining information and the intended use of the information which is sought will be relevant factors. Where a person becomes mixed up in another person's wrongdoing, and in doing so facilitates their wrongdoing, whether innocently or not, he comes under a duty to assist the person who has been wronged by giving him full information and disclosing the identity of the wrongdoer. The power of the court to order a person to provide information and documents in such circumstances is known as the court's Norwich Pharmacal jurisdiction. It is named after the first case in which the relief was granted. Norwich Pharmacal relief is most frequently sought against accountants, trustees and banks. It can be sought at any stage, including before proceedings have been commenced. It is commonly used to identify the persons involved in a fraud, or to obtain further information about a fraud. The relief can also be used to trace assets and to assist a claimant to police the terms of a freezing order. An application for Norwich Pharmacal relief should normally be made on notice. This means that the respondent will have an opportunity to attend the hearing of the application. If there is a need for secrecy, it can be made without notice. This may be necessary if the defendant or potential defendant might destroy evidence or attempt to place assets beyond the applicant's reach if they knew about the application. If this is a concern, the applicant can also seek a gagging order to prevent the respondent from telling anyone about the order. This will allow the applicant time to review the information obtained and consider next steps. There are a number of prerequisites for the availability of Norwich Pharmacal relief. First, the respondent must be somehow mixed up in the wrongdoing. Second, the respondent must be a facilitator of the wrongdoing, rather than a mere witness. This rule prevents disclosure being obtained from someone who could later be compelled to give evidence as a witness. There are exceptions to this rule. For example, where the applicant needs the information to identify a potential defendant or to properly plead its claim, and without it will be unable to issue proceedings. Third, the applicant must show that there is a good arguable case that there has been a wrongdoing. Fourth, the relief must be necessary in the interests of justice. Finally, it must be proportionate to grant the relief. The courts have put in place protections for third-party respondents. First, the applicant will usually have to pay the respondent's costs of complying with the order. Reasonable legal expenses are usually recoverable. Second, the applicant will generally have to undertake to indemnify the respondent if they suffer any loss in complying with the order. The information and documents which are disclosed will be subject to an implied undertaking that they will only be used in the proceedings in question. If the applicant wishes to use the material for other purposes, such as in connection with proceedings abroad, he will have to obtain the court's permission. The consequences of failing to comply with the Norwich Pharmacal order are serious. Failure to comply will be a contempt of court. A party who is held in contempt can be imprisoned for up to 2 years, subjected to an unlimited fine, and have their assets seized. In summary, Norwich Pharmacal relief is a very useful tool for victims of fraud, particularly in situations where there is clear evidence of a fraud, but it is unclear who the perpetrator is, or more details are needed before a claim can be brought. A practical example is this. Take a victim of an internet scam who has transferred money to the account of a company. The victim will know what bank account they have transferred the money to. However, they will not know who the signatory to that account is. If the recipient company is a foreign entity, the victim may not be able to find out who its directors are. However, the fraudster's bank should have these details in their KYC files. Therefore, a Norwich Pharmacal order against the bank may assist the victim of the fraud to identify the defendant. If the money is no longer in the account, the victim may also use Norwich Pharmacal orders to trace the money so as to recover it. I now move on to Section 236 of the Insolvency Act 1986. This section provides a mechanism for the officeholder of an insolvent company to obtain information and/or documentation from officers of the company or relevant third parties. The court can order respondents to appear before the court for examination, submit witness statements giving an account of their dealings with the company, or produce books, papers or other records. Subsection 2 provides the court with the power to summon specified persons to appear before it to answer questions. These persons are the company's officers, such as the company's former directors and company secretary, persons known or suspected to have the company's property in their possession or to be indebted to it, or any other person capable of giving information concerning the company's affairs. Subsection 3 provides the court with the power to require the same persons to provide an account of their dealings with the company in the form of a witness statement, or require them to produce books, papers or other records under their control relating to the company's affairs, including documents in electronic form. The courts have held that an order for the production of documents can extend to all documents which an officeholder reasonably requires to carry out his functions. An officeholder can seek an order under Section 236 for various purposes, such as to discover the truth of the company's circumstances, to put the affairs of the company in order, and to carry out their functions generally. This includes getting in the assets of the company and discovering the facts surrounding any potential claims. An application under Section 236 can be made without notice to the respondent. However, this may be considered oppressive unless there are good reasons for doing so. A prior written request for information may avoid the need for and associated cost of making a formal application. However, if the person who holds the information owes a duty of confidentiality, for example, in the case of a third party's banker, they may require an order under Section 236 before providing the information to override that duty. Before the court will grant relief under Section 236, the officeholder must satisfy the court that they need the information to carry out their functions. An officeholder's views on the need for information are normally entitled to a great deal of weight. Once the need for the material has been established, the court will carry out a balancing exercise to determine whether the potential importance of the information to the officeholder outweighs the potential oppressiveness to the respondents. The courts are more likely to find that an order would be oppressive where an order is sought against a person other than an officer, where there are numerous and wide-ranging requests for documents, and where an application is made without notice. As a general rule, an officeholder should not seek a Section 236 order against a person if they have already commenced or have definitely decided to commence proceedings against that person. However, this is not an absolute bar to an order being made. The court may find that the officeholder's need for the information outweighs the potential oppressiveness against the respondent. The officeholder's purpose in seeking the order must be to enable him to perform his duties, including investigating potential claims on behalf of a company. An application under Section 236 must not be designed to achieve an advantage in proceedings which would not otherwise be available. For example, it must not be used as a means to obtain early disclosure of documents. On a practical level, this means that officeholders should always consider using Section 236 before commencing proceedings. Information or documents obtained through the use of Section 236 are subject to a duty of confidentiality. This may be waived if the court is satisfied that the waiver is sought for the purposes of carrying out the officeholder's functions or is otherwise appropriate in the interests of justice. An officeholder is required to offer a reasonable sum to cover travel expenses incurred by the respondent in attending the examination. Other costs of compliance incurred by the respondents are subject to the court's discretion. A respondent may be required to pay the costs of the examination if it was only necessary because he unjustifiably refused to provide the requested information. The courts have the power to require an officeholder to pay the respondent's costs of compliance. However, they are unlikely to do so, as the provision of documents to an officeholder is considered to be a matter of public duty. If a respondent fails to attend court for examination, or there are reasonable grounds for believing that he has absconded or is about to abscond, a warrant may be issued for his arrest or for the seizure of documents in his possession. Failure to comply with an order under Section 236 for the production of documents is a contempt of court. A party who is held in contempt can be imprisoned for up to 2 years, subjected to an unlimited fine, and have their assets seized. In summary, Section 236 is another very useful tool for officeholders seeking to obtain information from third parties. It will be of particular use to officeholders investigating a suspected fraud. It can be used to obtain a wide range of information and documents from third parties at an early stage in the insolvency process to identify potential claims. A practical example is this. An officeholder may believe that company assets were fraudulently appropriated by its former directors, but might have difficulties investigating this if the company's email servers were wiped prior to its insolvency. The officeholder could investigate the company's affairs by obtaining an order requiring the directors to produce copies of the company's electronic records, including emails sent from the company's email accounts, retained by the directors. The key difference between Norwich Pharmacal orders and Section 236 orders is that while Norwich Pharmacal orders are available to any litigant, and even before proceedings are commenced, Section 236 orders are only available to officeholders. Applications under Section 236 will be most appropriate at an early stage in the insolvency process, where the officeholder is seeking information relating to the company's affairs in order to identify potential claims, and the company's officers or other third parties are likely to have such information. Norwich Pharmacal relief may be a more appropriate remedy where the third party from whom information is sought has little connection to the company, or where proceedings have already been commenced. The consequences of failing to comply with a Norwich Pharmacal order and a Section 236 order are serious. They are both, therefore, powerful tools in fraud litigation.